Regents of the University of California versus Bakke, decided June 28, 1978, argued October 12, 1977, presented by Christian, Alexis, Jenny, Brian, and Andrew. Alan Bakke, a 35-year-old white man, applied for admissions to the University of California Medical School at Davis 2 times. Bakke wanted to be a physician. Bakke was rejected both times. The University of California Medical School at Davis sought the greater racial and ethnic diversity in its student body. Bakke was one of many applicants for 100 entering positions at the Davis Medical School. 84 spots were filled through a regular admissions program. 16 slots were filled through a special admission program. The special admissions program was a distinct separate process established to address the faculty's concern over the less African American, Asian, Latino, Native American, and other minority group students. Grade point average and standard test scores requirements were much less strict than for students admitted under the regular program. In 1973, Bakke scored 468 out of 500 and was rejected. In 1974, Bakke scored 549 out of 600 and was rejected again. He was rejected both years even though he had a higher score and a higher grade point average than most applicants. In both years, Bakke wanted placed a discretionary waiting list even though he had good scores and slots were still unfilled. Bakke filed a lawsuit alleged that the Davis program violated the Civil Rights Act in 1964. Forbidding racial or ethnic preferences in programs supported by federal funds. The university, setting aside positions for minorities, also denied him equal protection under the 14th Amendment, violating the Constitution. The university agreed that racial classifications are disfavored because racial characteristics are not important to permit state objectives. The university stressed that the programs enrich medical education through a diverse student body, making successful role models for minority communities and better medical services for minority communities. Both the state trial court and the state Supreme Court ruled that racial excluded preferences constituted a quota, and those quotas absent of finding a prior discrimination by the university itself were a denial of equal protection. The U.S. Supreme Court was closely divided in many different opinions. Judge Stevens, Berger, Stewart, and Rehnquist to address statutory rather than the constitutional issue, the meaning of the Civil Rights Act, and its prohibiting of any individual and racial background from publicly funding programs and were sufficient grounds. In the judgment of the order, Bakke admitted, Judge Brennan, Marshall, White, and Blackman cited as long as the state can demonstrate an important purpose and the means do not unjustifiable burden the least represented in the political process, race conscious decision to help members of the group and that had suffered racial motivation injuries were constitutional. The vote was 5-4. Powell cast the deciding vote, agreed with Stevens, Berger, Stewart, and Rehnquist. The U.S. Supreme Court held that a university may consider racial criteria but out of the competitive admissions process so long as fixed quotas were not used. Bakke was admitted. Yay!